start recording and we'll get started. Okay, hi everybody, you are very welcome. Thank you so much for registering. Thanks for coming along to our lunchtime talk on tenants' rights. So we're delighted to have you here. We really hope this will be a useful session for people. I'm the manager, Claire, here in Ballymun Community Law Centre. My colleague and the managing solicitor here, Gary Lee, will be the one delivering the talk. Gary is an experienced human rights lawyer with expertise in disability and equality, a lot of experience here in Ballymun with various cases over the last 5 years. He's the chair of the Law Society Human Rights and Equality Committee and a general advocate for social justice and for access to justice here in Ballymun. So Gary will be your host. Before he starts, just some housekeeping. It is being recorded, so that some people who couldn't make it today can watch back afterwards. There will be time for questions and answers, and we really encourage that. We're both keen that if there's anybody here who has a particular issue in mind, that they have it addressed. So just use the Q&A box there for the questions, and then it's just Gary and I who can see those, and Gary will address them as we go. When you leave or when we end the webinar, a screen will pop up asking you for some feedback. We wrote those questions ourselves, and we'd be really grateful to hear your feedback. It'll help us improve for next time. So that's it, and with that I'll hand you over to Gary there. You go, Gary.
Thanks, Claire. Claire is going to be looking after the technical side of things today, and I'll be moving my slides. I don't trust myself with technology, so thanks, Claire. Again, as Claire said, anybody has any questions, pop them in the Q&A function there on the system, and be happy to answer them as we're going along. We have a couple of questions sent to us in advance. Thank you very much for people that sent those in, and I'll hopefully answer them as we're going through the talk today as well. So if we could have the next slide, Claire. So Ballymun Community Law Centre. So we're a not-for-profit law firm. We don't charge our clients any fees. We seek to empower individuals experiencing disadvantage and to give the people in the community access to justice by providing free legal advice, information and legal representation, primarily in the areas not covered by the civil legal aid scheme, but we do so a lot of it would be housing, social welfare, access to healthcare, consumer matters, and so on. We have a legal education program as well, a mediation service, and training in mediation skills. So essentially, we try to remove barriers to the law in the local community here in Ballymun. We act for individuals and NGOs in the Ballymun area. So look, you're welcome everyone to today's lunchtime information session. And today we're going to be looking at residential tenancies rights and obligations. So if you'd have the next slide, please. And specifically at tenants of private landlords and of approved housing bodies. So I hope to address tenants of local authorities in a separate future talk. So as a tenant, you have two principal sources of rights and obligations, and those are your rights and obligations in legislation, and also rights and obligations found in your written tenancy agreement, if you have one. So there are various matters that the courts also have ruled on over the years that affect landlord and tenant law as well. So next slide. A quick word about social housing. So you may qualify for social housing or social housing assistance. You may, in fact, be in receipt of social housing assistance. You may be housed by a social housing tenant, either by the local authority or by an approved housing body, or you might be in receipt of housing assistance payment, or HAP, as it's known. Additionally, you may be in receipt of the older version of the rental accommodation scheme, which RAS, which is which is fastly being replaced by HAP. So essentially, where HAP is where local authorities contract with private landlords to provide housing for a specific period of time, and then the rent is paid directly to the landlord. So I hope to look specifically at social housing from a tenant's perspective at a later lecture. But obviously, if you're being housed in social housing by either an approved housing body or a private landlord, then what I say in today's talk is going to be applicable to you, albeit that there are some differences, for example, around declaring any increase or reduction in household income. So if we look at the acts, if I could have the next slide, please. Claire, that's the wrong acts. We'll try again. Next slide. Yeah, they're the sort of acts I had in mind. So the legislation governing your rights and obligations as a tenant are primarily found in the Residential Tenancies Acts 2004 to 2020. But other legislation might be applicable as well. And in that regard, we're going to have a look at the Equal Status Acts and the Data Protection Acts. The property also has to adhere to certain minimum standards pursuant to the Housing Standards for Rented Housing Regulations 2019. So they're the primary acts that govern landlord and tenant relationships. So I suppose let's start at the beginning, which is, I suppose, as good a place as any to start. You're looking for a suitable property to rent. So the first thing you should know is that a landlord or a prospective landlord can't discriminate against you on any of the grounds provided for in the Equal Status Acts. Now, those grounds are gender, civil status, family status, sexual orientation, religion, age, race, membership of the traveller community, disability, or indeed if you are in receipt of or are applying for housing assistance payment for HAP. Landlords, and obviously their agents too, are also subject to the Data Protection Acts and the General Data Protection Regulation. So the landlord is entitled to, and indeed most will, look for certain information from you when you start to engage with them first. But that information or data has to be adequate and relevant and not unreasonably excessive for the purpose of letting the property. So the landlord will typically look for the likes of payslips, photo ID, references, for example, from your previous landlord or from your current employer, recent bank statements, PPS numbers, or perhaps even residence references in relation to your residency status. So the practice as well of prospective candidates for tenancies being required by landlords or their agency or their agents to submit copious amounts of data is strongly frowned upon by the Data Protection Commission, which actually issued a statement around this. So people, before they were actually allowed to view a property, had to submit a lot of data. That's not allowed, and the Data Protection Commission was so concerned about that, it has issued a policy statement in relation to it. Remember as well that you're entitled to get copies of any of your personal data, and we would recommend that if you're going to do that, that you send a request, you give a request in writing to your landlord seeking that data. An email would be a good way to do it. So that request is known as a subject access request, and you're entitled to that data within 30 days of requesting it. There are exceptional cases where a landlord could say, well, look, it's going to take me up to 3 months to get it. So they can, under exceptional circumstances, extend that period for 3 months, but it would be hard to see under what circumstances that they could actually do that. And also, if you keep your request fairly narrow and specific, they shouldn't. They should do it within 30 days, and that's the law. So, okay, you're lucky enough to find a property in the current climate. You submitted your data, and your landlord has agreed to rent it to you. You will be asked to pay a deposit. This is usually the equivalent of 1 month's rent. And you should note that by law, a landlord can't ask you for more than 1 month's rent. So if the landlord is asked, so typically you'll be asked for 1 month's rent in advance, and sorry, deposit, I should say, and 1 month's deposit. So the landlord cannot ask you for any more than 1 month's deposit. Now, the only exception to that is where it's a student-specific accommodation and both parties agree to a higher deposit being paid. Next slide, please. The majority of tenancies will have a written tenancy agreement, although there's no legal requirement for a written tenancy agreement, but it certainly would be foolish for both parties not to have a written tenancy agreement in place. But there is no legal requirement to have one, and people are often surprised about that, but there isn't. The agreement itself should, at the very minimum, contain the following provisions, and that would be, they're fairly obvious, but we'll go through them anyway. The parties, so who is the landlord and who is the tenant? The property being let. You'd be surprised the number of tenancies that I look at when I'm acting for tenants, and the property isn't even described in the tenancy agreement. So make sure that the property is properly described in the tenancy agreement. The term for which the tenancy agreement lasts, and that's very important again. I mean, how long is it to last for? And again, I've seen tenancy agreements, you know, with all the bells and whistles, but they don't actually have how long it's going to be leased for. Usually, the usual period is 12 months. An inventory of appliances, furniture, and so on, very important, and very important from the point of view of the tenant as well, to make sure that they are detailed, and if there's any damage to any of those when you're taking over the property at the beginning, let your landlord know, have that noted. You might have to have the item replaced. Very importantly as well is the rent and the rent dates. So that should be in the tenancy agreement. And then the rights and responsibilities of both the landlord and the tenant. They should be very clearly set out in the tenancy agreement. Also, who pays for the utilities? If it's the tenant, that if you're paying for all the utilities as a tenant, or if you don't have to pay for certain utilities, make sure that that is noted in the tenancy agreement. And as we'll see in a bit more detail later, if the landlord wishes to prevail of the probationary 6-month provision, then that must be covered in the lease. Otherwise, if the lease is for longer than 6 months and that isn't covered in the lease, then you as a tenant, you'll have your full statutory rights will automatically accrue from the start. So again, it's important to check that and to know that your statutory rights don't click in until you've been in occupation for 6 months. So the exception, of course, on that one is that approved housing bodies, where if it's a transitional accommodation that we're looking at, and the lease is for up to 18 months, in such circumstances, Part 4 rights will not actually accrue to the tenant. And we look at those Part 4 rights in more detail later. One issue that arises a lot as well is whether or not, and if we go on to the next slide, please, is whether or not a tenant can keep a pet in the property. and that's my dog Bella. So she's 2.5, and she's a very affectionate dog. But there's no entitlement in law for me to have her in a rented accommodation. So it's very important that that Bella be included in the tenancy agreement, so that there's a right, in this case, that there's a right to have a dog, or you might want to have a general right to keep pets in the property. But it can be very upsetting to people. They move in and then they find that, you know, a couple of weeks into it, a neighbour is complaining maybe, and then it turns out that there's no entitlement in the tenancy agreement, or even worse, that there's actually a ban on having dogs in the tenancy agreement. And then they have to, they have to look for alternative accommodation for either their pet or both of them. And if you see there, just at the side of generally, Bella is a very good dog, but occasionally she likes to have a little bit of a chew. So if you're a tenant, you be aware that you're responsible for any damage that your pet might cause to the property. And also in terms of any noise. So if your dog is barking late at night or into the night, and there's complaints coming in, then obviously that's your responsibility as well, and your responsibility under the tenancy agreement as well, to your landlord, as well as to the neighbours. So if we could have the next slide. So as I previously said, you enjoy rights under the Residential Tenancies Acts 2004 to 2021, and your landlord, the first thing your landlord has to do is register the tenancy with the Residential Tenancies Board within 1 month of the commencement of the tenancy. And to do this, they'll need certain information from you as the tenant, including your PPS number. The registration itself can be, completed online, but you can check the register to see if your tenancy is registered. Now, if your tenancy is not registered, I would strongly urge you to get onto your landlord and ask your landlord to register it. But if the landlord doesn't register it, or indeed refuses to register it, then you can report the matter to the Residential Tenancies Board, and they can take the matter up from there, and contact your landlord and have the property registered. So, as I said before, the rights granted to you pursuant to the legislation, and the rights that you get under these Residential Tenancies Acts are known as statutory rights. And you may also be familiar with the term Part 4 rights. Now, these are statutory rights under Part 4 of the Residential Tenancies Act 2004, which gives tenants security of tenure. Now, by security of tenure, I mean the right to stay for a specific period. It usually happens, as I said, automatically once the tenant has been in occupation for a period of 6 months. But again, I just remind you that if your landlord is an approved housing body, there are certain exceptions to your statutory rights, including that 6 month probationary period. But the exceptions themselves are fairly obvious, but we just have a look at them anyway. So a tenant of an approved housing body can't assign or sublet the property. The grounds for termination of the tenancy obviously as well don't include accommodation of its own family members or indeed itself. Security of tenure does not apply, as I've said, if it's an approved housing body and it's transient and less than 18 months. Rent reviews are permitted as per the tenancy agreement, but when it comes to approved housing bodies, they are limited to 1 in any 12-month period, and notice of any such review should be given to you as a tenant of an approved housing body as soon as possible. Right, so let's look at security of tenure for Part 4 tenancies. That means how long do you have, regardless of what the tenancy agreement says or your landlord's doing, how long a right do you have in terms to live in the property? If your landlord, for example, wants to terminate for any of the grounds provided for under the Residential Tenancies Act, how long does that notice have to be? So if we're looking at tenancies, Part 4 tenancies that were created after the 24th of December 2016, so if you have that, then you have a 6-year cycle. So you're entitled to a 6-year tenancy. So that's security of tenure for a period of five years and 6 months after the expiration of your 6-month probationary period. And that's the law in relation to that. So you recall that within the first 6 months of the tenancy, either party can terminate the tenancy without satisfying any of the statutory grounds for terminating a tenancy. However, if you've been given, as I said, if you've been given a fixed term for longer than 6 months, then the landlord will not be in a position to terminate based on that 6-month probationary period, because you've got the property for longer than 6 months. It should also be noted that the Residential Tenancies Amendment Act of 2021, and this is very important if you're a tenant, provides that from the 11th of June of 2022, all new tenancies created will be for an unlimited duration once the tenancy has lasted more than 6 months. So you're entitled to stay in the property regardless of what your tenancy agreement says. If your tenancy commences after the 11th of June 2022, then you're entitled to stay in the property forever, provided there's no provided that the landlord doesn't wish to terminate for any of the grounds that the landlord is entitled to terminate for. So again, there's that exception for the 6-month period in terms of approved housing bodies. And as well, I just note that unfortunately for students, but Part 4 tenancies, Part 4 rights don't apply to student-specific accommodation. So the majority of tenants that contact our law centre here after being informed that their tenancy is being, really, they come to us really, I suppose, after they're informed that their tenancy has been terminated, or their rent has been increased, or where the landlord has failed to carry out certain repairs. So we'll look at each of those in detail in a minute. I'm just going to, there's a question here, is what would be considered an excessive request for data from a landlord who wants to rent a property to a tenant? Well, I think anything above the data that I listed out wouldn't be, would be excessive, unless there's a good reason to want to look for that data. So the landlord has to have a good reason to look for the data. Again, what about assistance dogs? Again, I would err on the side of caution and put that specifically in. But there are, there's disability. You can't just discriminate on, for example, on the grounds of disability. And if somebody obviously has a guide dog, then and you're preventing them from bringing the guide dog into the home, you could be seen to be discriminating on the grounds of disability. There's a whole question that we can talk about in terms of reasonable accommodation for people with disabilities, and it should. That reasonable accommodations should extend to cover the private sector and private landlords, but unfortunately there are issues around that. But it is a very interesting question, and thanks for bringing it up. But I would put it in there specifically into the agreement. Again, if you have a difficulty around that, it's an issue that that the accommodation of people with disabilities is something that that I would have a lot of experience in, and if you have any issues around that, you can contact me here in the law centre. I would certainly be very interested in talking to you in relation to that. So if we could go on to the next slide, Claire. So once your 6 month period has elapsed, and forgetting about the case of the approved housing bodies, but if it's more than 18 months, it's not transient. But generally speaking, once you've been in occupation for more than 6 months, your tenancy can only be terminated for one of the grounds of termination provided for in the Residential Tenancies Acts. And those grounds are, the first one is that the tenant has breached their obligations. So, for example, the property has been damaged beyond usual wear and tear. The landlord would then have to give a written warning notice. That notice should detail what the breach is and give you as a tenant sufficient time to remedy that breach. If the breach has not been remedied within this time, then the landlord can serve a 28-day termination notice. And this is regardless of how long the tenancy is in existence. And as with all matters relating to termination of tenancies, the landlord must not only be substantively entitled, but they must also get the procedures right. So that your landlord might actually be well within his or her rights to terminate your tenancy. But if they get the wording, for example, of the termination notice wrong, and provided this so-called slip rule, which we'll discuss in a minute, can't be invoked, then this could well invalidate the termination. And I think it would be worthwhile to look at termination notices in some detail, which we will do that later. But I'm going to mention the two breaches of tenants' obligations, which are treated differently and understandably so, but they're also the ones that we see the most of here in the law centre. And the first relates to antisocial behaviour, and then the second relates to non-payment of rent. The other grounds for terminating a Part 4 tenancy are that the property might no longer be suited to the tenant's needs. So say a studio apartment was originally let to a couple, and then that couple have children. Well, then the studio apartment probably would no longer be able to sustain that household, and it would, even from the point of view of wear and tear on the property, it wouldn't be suitable. So the landlord, the other one is the landlord or the landlord's family member wants to reside in the property, or the landlord wishes to sell the property. Now, if this is the case, your landlord must also fill out a statutory declaration to the effect that they're going to sell the property within 9 months. And I've acted for quite a few tenants in disputes before the Residential Tenancies Board, where we successfully challenged the validity of this statutory declaration. Another ground then is around the substantial refurbishment of property. And this is a ground that was very often used in the early days by landlords. And indeed, I acted in a few cases, quite a few cases, where we successfully challenged this ground on behalf of the tenant. And remember now as well that the law has been very much tightened up, and that the landlord will not get away with anymore with passing off minor alterations as substantive refurbishments. So now when the landlord is serving a termination notice, it'll have to give you as the tenant certain information, including naming the building contractor that's going to be engaged and carry out the work, and the date upon which the work is going to be carried out, how long it's going to take to carry out the work, and whether or not planning permission is required. Additionally, either in the notice itself or in a certificate given along with the notice, the landlord has to state that, that the property has to be vacated due to health and safety reasons whilst the work is being carried out, and that that period of risk will exceed 3 weeks. Now, once that has been done, and if that has all been done correctly, and you move out of the house and the works are carried out, well, you are given the first right of refusal basis. That property has to be offered back to you as a tenant to rent. So the final ground for termination would be far rarer, and that relates to a change of user, say from residential to retail. Again, that's a very rarely used ground. So if we could go on to the next slide, Claire. The one that I'm going to look at in a bit more detail is around antisocial behaviour. Now, this is the breach, as I said, which tenants consult the law centre most often about. And I think we need to carefully consider the nature of the alleged breach. So when a tenant comes into us, we have a look. Well, what is the alleged breach? And we'll have a look, and we'll take instructions from the tenant as to what exactly has happened. And then we decide, well, does that actually constitute antisocial behaviour within the meaning of that term? And if we feel that it does, then we look to see whether or not the statutory procedures have been complied with as well. So remember, the landlord has to be substantively right, I should say, and procedurally right. So there are two types of behaviour that constitute antisocial behaviour, and one is more serious than the other, as we shall see. There's two termination periods, which is reflective of the more of the serious nature of the second type of antisocial behaviour. So the first notice period is 28 days, and the second one is 7 days. So you'll have to bear with me for a little while here. So I think it's worth going into and having a look at this section. So Section 17(1)(c) of the Residential Tenancies Act 2004 defines the first category of antisocial behaviour as to engage persistently in behaviour that prevents or interferes with the peaceful occupation by any other person residing in the dwelling concerned of that dwelling. So basically any of your housemates, anybody else in your household, by any person residing in any other dwelling contained in the property containing the dwelling concerned. So basically anybody else if you're in a block of flats, for example, anybody else in that particular block. And then finally, they have a catch-all one, any person residing in a dwelling in the vicinity of the dwelling or the property containing the dwelling concerned. It's a long way about saying that, look, anybody in your neighbourhood, basically, as well. So your house, the building that your home is in, and your neighbourhood. They're the three areas. Now, if the landlord seeks to terminate the tenancy on this basis, then a written warning notice has to be issued to you, calling upon you to decease the behaviour. And if the behaviour persists, then the landlord is entitled to serve a 28-day termination notice terminating the tenancy. So warning, and then a termination notice if you don't comply. The second and more serious type of antisocial behaviour is defined in Section 17(1)(a) and (b), and it's defined as behaviour that constitutes the commission of an offence, being an offence the commission of which is reasonably likely to affect directly the well-being or welfare of others, or to engage in behaviour that causes or could cause fear, danger, injury, damage, or loss to any person living, working, or otherwise lawfully in the dwelling concerned or its vicinity. And this includes violence, intimidation, coercion, harassment, or obstruction of or threats to any such person. So to invoke that ground of antisocial behaviour, it clearly has to be an extremely serious matter. It's not, you don't have to show that the person has been convicted of it, but the level of proof there, as we say, would be quite high in relation to that. So you'd have to, your landlord would have to adduce quite strong evidence. So, for example, statements from neighbours, witnesses, CCTV, that sort of thing, in order to back up the issuing of a 7-day termination notice. It's worth mentioning as well, I should say, that your landlord has obligations and responsibilities to third parties. If their tenants engage in antisocial behaviour that impacts upon a third party, the landlord owes a duty to enforce the responsibilities of the tenant to each person who could be affected. So in cases where a landlord fails to enforce a tenant's responsibilities, a person directly and adversely affected may take a case against the landlord themselves to the Residential Tenancies Board. So that's why a landlord has to take complaints of antisocial behaviour quite seriously. Indeed, there is a personal responsibility as well on the landlord, potentially, that could be complained of to a third party. Next slide, please, Claire. So where a tenant fails to pay their rent, so if the tenant breaches their obligation to pay the rent, and that's the main obligation you have as a tenant, is to pay your rent and pay it on time. So if you fail to pay your rent in full and on time, then your landlord, regardless of how long you've been in the property, your landlord can serve a 28-day warning notice, essentially giving you a chance to pay off the arrears within that period. Now, it should be noted here that the landlord must send a copy of this warning notice to the Residential Tenancies Board as well, at the same time as the landlord is giving you that notice. And the period, the 28-day period, will only run from the time that both notices have been served. So again, if the notice is not paid, if the rent is not paid within that 28-day notice period, then a 28-day termination notice can be sent to you, can be served on you. And this too, if that's served on you, but the landlord also has to serve it on the Residential Tenancies Board as well, at the same time, the same day. Next slide, please, Claire. So once one of these grounds have been established, your landlord needs to ensure that the correct statutory notice period is given to you. And as I've said, this will depend on the length of time that you as a tenant have been in occupation of the property. So I'm going to go through those periods now. I'll refer you to the Residential Tenancies Board website. They have the same notice periods. In fact, they have other information, relevant information there as well. I would refer you to their website, but I will just briefly go down through those notice periods. So, as I said, you have to be in occupation for 6 months for the rights to accrue. But if a notice on any one of the statutory grounds is served on you, and you're there at least 6 months, but less than 1 year, you get 90 days notice. Not less than 1 year, but less than 3 years, you're entitled to 120 days notice. And not less than 3 years, but less than 7 years, you get 180 days notice. Not less than 7 years, but less than 8 years, you're 196 days notice. And if you're over 8 years, or not less than 8 years, as the provision says, you have an entitlement to 224 days notice. So be clear of those notice periods. So, okay, your landlord thinks that one or more of the criteria for terminating the tenancy has been met on the preceding grounds. As I said, they need to make sure that the procedures are being met. If those procedures aren't being met, then the Residential Tenancies Board itself can invalidate the termination notice. And I've acted against landlords who stubbornly or perhaps ignorantly stuck to obviously flawed termination notices in the past, hoping that they would somehow do, or that the slip rule would be applied, only to find the Residential Tenancies Board invalidating the notice and the landlord going back to square one. The slip rule, I know I mentioned that before, so the slip rule came in 2016, and it allows an adjudicator or a tribunal to overlook a minor error in the notice of termination once that error does not prejudice the notice itself. So only for that error the notice would have been valid, and it's a minor error, then the adjudicator or the tribunal can overlook it. But if you're a landlord, and this is important as well, people forget this, or even landlords forget it, if your landlord knew or ought to have known that the termination notice was invalid and they acted upon that notice, then they will actually have committed an offence. So in such a situation, so if that does occur, so if a landlord relies on an invalid notice, then prima facie anyway, that landlord, has committed and relies on has committed an offence. If they continue to rely on a notice that they know is invalid. And if that is the case, then you as a tenant might be entitled to get damages of up to €20,000, and the landlord might be ordered to put you back, to reinstate you back into the property. So it is worth remembering that. The 2019 Act brought in the concept of a remedial notice. So where an adjudicator or tribunal identifies an issue with a notice, and if the adjudicator allows it, the landlord can actually serve a remedial notice within 28 days of the adjudication order being made in the Residential Tenancies Board. So can I have the next slide, please, Claire? So we'll look at the termination notice itself, and you'd be surprised how often landlords get these wrong. So as a tenant, that's the first thing I would do. You have 28 days to challenge this from the day that it's served on you. So you don't want to go through that 28-day period. I'm going to mention that again because it's a really important period, the 28 days from the date that it's served on you. So the notice itself must be in writing. So an email or a text will not suffice. And it must be signed by either the landlord or authorised agent. So I had a dispute where the supporting affidavit was sworn by a director who said in the affidavit that he owned the property and he intended to sell the property on. Now, this is actually incorrect, as that person did not own the property. Rather, he was a director of the company which owned the property. And in that case, the argument was accepted and the notice was deemed invalid. Another dispute I had involved the notice being issued by a company, which was actually a company that was a different entity to the landlord. And that company was not the landlord's agent. There was no evidence to say that that company was the landlord's agent. So it's important that you check that and you check who is actually serving this notice on me. Is it the landlord or is it the landlord's agent? And how do I know it's the landlord's agent? Have I been informed? There's a duty on a landlord to inform you that an agent has been appointed or an agent has changed. So look at that. The reason for the termination must be clearly stated on the termination notice. So what ground is the landlord relying on? And that must be clearly stated in the termination notice. And the correct notice period, we've looked at those notice periods, the correct notice period must also be given. And so the date, and so should the date upon which the tenant has to vacate the property. And that must be clearly stated on the termination notice. So I've had a number of cases where the notice period has been incorrectly calculated by the landlord. And remember, if the landlord is short by even a single day, the notice itself will be deemed invalid. And remember that the landlord also should specify on the termination notice that you have a full 24 hours on the termination day to vacate the property. The period as well starts, so that period starts the day after the notice has been served. So I quite often see the landlord calculating the day of service as being day one, when it's actually the following day. So landlords have been out for a day as well. Obviously, if I was a landlord, I'd stick in, maybe give people 2 or 3 days above what you think their period is, and then you're going to avoid these issues. And the landlord also has an obligation to tell you that you can file a complaint in relation to the termination notice within 28 days. Now, the landlord also has to file that termination notice within 28 days of the expiration of the termination date. So once that, the landlord serves the notice on you, 28 days have gone by, then the landlord has to serve that notice on the Residential Tenancies Board as well. So when it comes to I suppose when a tenant comes to us here in the law centre, the first thing we do is check the procedures and the technicalities and make sure that they have been complied with. So my strong advice is that if you are served with a termination notice and you live in Ballymun, contact us immediately, make an appointment, and we'll have a look at the termination notice for you. Alternatively, if you do not wish to avail of our services, or if you're outside of our area, you can check it yourself. If you can afford, obviously, you can afford to go to a solicitor, go to a private solicitor to advise you. And again, I'd refer you back to the Residential Tenancies Board website as well, and that's helpful, and that can guide you as well. So if you have the next slide, Claire. I'll just say that maybe we just have the slide after that, Claire. Might just not be in. We'll go back to the repairs one. I was going to mention that the Residential Tenancy Board provides a mediation service so that disputes can be resolved by way of mediation. So if you have a dispute with the landlord and it is persisting, then I'd advise you just to bring a complaint to the Residential Tenancies Board. You can submit that online, and in the first instance, that complaint will be heard by an adjudicator, with appeals from the adjudicator's determination going to the tribunal. But you might also avail, as I said, of the mediation service that the Residential Tenancies Board provides. And the cases that we get in here in the law centre, as I said, they primarily relate to termination of tenancies, incorrect rent reviews, and failures to carry out repairs. So maybe we'll look at the landlord's responsibilities when it comes to minimum standards and obligations to repairs. So the first thing that I will point out when it does come to repairs is that you as a tenant are under an obligation to inform your landlord of any repairs that might be needed to be carried out, and as soon as you become aware of them. And you must generally as well also allow your landlord or their agents access to the property, obviously, to carry out these repairs if access to the property is required. But of course, you have to be given reasonable notice. I should probably mention as well, generally your landlord is entitled as well to inspect the property from time to time, but again, the landlord has to give reasonable notice if they're going to carry out any inspections to the property. Your landlord is legally obliged to maintain the exterior and interior of your property and to carry out any repairs in a timely manner. So the property must adhere as well to certain minimum standards. If not, or if your landlord refuses to carry out repairs, then you, as I said, you can bring a dispute to the Residential Tenancies Board. But remember, you can also make a complaint to your local authority if the property doesn't comply with certain standards, or if you believe that your home is not a safe or healthy environment. Tenants rarely use that particular referral method. You can do the two. I mean, refer to the RTB and refer to the local authority under the minimum standards. But in my experience, tenants rarely do that, and maybe they should be exercising that right more. So if you could have the next slide, Claire. So it is worth looking, given that it is worth looking then obviously at the landlord's obligations in terms of the housing standards for rented houses. And you'll find the latest regulations are the 2019 regulations, SI 137 of 2019. And it's certainly worth familiarizing yourself with these standards to see, as I said, if you could use them to get your landlord to take remedial action if required. And remember that there's a serious incentive for your landlord to comply with these standards, because failure to comply with the regulations could potentially result in your landlord being prosecuted. So a very serious matter for a landlord indeed if they're found guilty, if the prosecution found guilty of breaching the minimum standards. So there is a serious incentive on the landlord to do that. The local authority is charged with policing the standards and carrying out inspections of rented properties. We looked briefly at the main provisions in the regulations. The standards deal with various matters, including the structure of the property. The property must be maintained in a proper state of repair, which is defined in some detail in section 4.2. So I'm not going to go into too much detail, just say that, for example, it says it has to be safe and good working order. The bathroom must be separate, must have good ventilation. There must be proper heating facilities in the property, so any habitable room has to have a heater in it. There's provisions regarding food preparation, storage and laundry. It's worth pointing out that although the approved housing bodies are effectively, they're exempt when it comes to certain regulations around the kitchen area and also the obligations in terms of laundry facilities. You must also have access to a fire blanket and fire alarms, but they should be serviced and checked out regularly, and access to refuse bins. But again, if you Google standard for rented houses, you'll see the entire list there. And I know, just before I go on, there was a couple of questions there. Can a non-HAP tenant get a local authority to inspect for breach of housing standards regulations such as mold? Yes, absolutely. So if you have a private landlord, if your private landlord is breached, so the standards don't just apply to people in receipt of housing assistance payment, they apply to equally to private landlords. So I would put you would be entitled to put a complaint. Something like mold obviously is a health and safety issue, so it's the environment of the property, and that would be serious. So I would advise to do that. Mother lived in DCC rented house 28 years, bath and toilet are discoloured and in bad shape. Is she entitled to have them replaced? Well, first of all, I'll say is that the threshold that local authorities have to comply with is quite low compared with private landlords and approved housing bodies. So unfortunately, you don't have the same level of rights. In terms of the bath and toilet, if they're discoloured, well, no. Bad shape, it depends what you mean by bad shape. If they're not in working order, then there'd be an obligation, obviously, on the local authority to fix them. If they can't fix them, well then yes, they should be replaced. But if they wouldn't be entitled to get them replaced just because they're there for 28 years, unless they were broken. So another question here. If a tenant in a private rented accommodation engages in antisocial behaviour, could a neighbour of this tenant take the landlord to the RTB if she does not sort out the tenant? Yeah, that question is probably lodged in before, but I did actually answer that question. That is the case. As to the validity of the notice or the right of the landlord to serve it, it must be referred to the Residential Tenancies Board in 28 days from the receipt of the notice. What happens if you don't do it within this time frame? Are you statute barred? Is there anything that can be done outside of the 28 days? So if the notice yeah, there'd want to be a good reason as to why you didn't make the complaint bring the dispute within the 28 days. So you really should do it within the 28 days, and ignorance is not. It's not. I would say if the landlord, for example, failed to put in a provision in the termination notice to say that you have 28 days, and that was and you were pointing that to say that that's invalid, then maybe under those circumstances the adjudicator the Residential Tenancies Board might well accept your dispute. Generally speaking, the 28 days is quite a strict period. But obviously, if you didn't know about it because the landlord didn't tell you about it, and the landlord breached its obligations to tell you about it, well then under those circumstances you could bring it. I would put an application in anyway, and even if you are outside that period. I would put an application in anyway and have that determined by an adjudicator. That would be my take on it, albeit that it might be actually difficult to persuade an adjudicator to allow the dispute to proceed. But I would put it in there, and you might well have grounds to do that. So. Do we have one other question? No. So I think that almost finishes us. The one thing I will say is that I'll mention that you are entitled to quiet and peaceful enjoyment of the property that you rent. Your landlord must leave you in peace to enjoy your property. Now we're going to send out just after this. We're going to send out a questionnaire just to give us some feedback on it. Appreciate if you do that. From me, I'm going to hand you over to Claire. Thanks. I just want to say thank you very much for listening in, watching in today, and I'll hand you over to Claire now. Thank you. Bye-bye.
Thank you, Gary. Okay, that's it, everybody. Thank you very much. As Gary has said, we are here, and Gary is available for anybody with issues in the Ballymun area. So just have a look at our website, bclc.ie, for our contact details, and just give us a ring if you're not sure of anything. So look, thanks for all the questions and the participation, and thanks for joining us here today. That's it from us. The survey will come up when we finish the webinar. Thanks very much. Bye, everybody.
Bye. Bye.